Hi, everyone. Thank you for joining today's webinar presentation, The Business of Patent Practice, Efficiently Producing Quality on a Budget. I'm Gail Martin, Associate Marketing Manager at Reed Tech, and I want to cover a couple things before we get started. Please feel free to submit questions during the conference by using the chat or Q&A feature and sending your questions to host. We will be sending you a copy of the slides and a link to the recording from today's presentation. Now I'd like to introduce today's presenters. Jean Quinn. Jean is the founder of IPWatchdog.com, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Jean was recently named on one of the world's leading IP strategists by IAM for the second consecutive year. Carrie Jordan. Carrie is a partner in the Houston office of Voorhees, Spader, Seymour & Pease, LLP. She is a patent veteran with 2 decades of experience handling patent prosecution matters, patent challenges, litigation, and intellectual property counseling for large and small clients. And Megan McLaughlin. Megan is the product director for Patent Advisor, a suite of patent prosecution management tools. Previously, she worked as a patent attorney at the law firm of Nutter, McClellan & Fish, primarily drafting and prosecuting patent applications. She is co-host of the LexisNexis IP podcast, Better Patents Now. Thank you again, everyone, for attending today's presentation. And with that, I will turn it over to you, Jean.
Great. Thanks a lot, Gail, and thank you all for being here with us today to talk about this topic. It's an interesting topic. It's one that, it's unfortunate that we have to have a webinar like this in a lot of ways, because it's just the new business reality is probably everybody on this webinar knows. Clients are increasingly wanting us to do more and more for less and less. As inflation is growing, as the Federal Circuit and Supreme Court continue to want more disclosure to go into each patent application, clients continue to want to find ways to pay patent attorneys and law firms less in order to produce the same high quality, which just is, patents are getting longer and more dense than they once were, and we've got to find ways to do that. And we also have to find ways to try and convince clients that that may not be in their best interest. So we're going to have sort of a 2-part webinar here today. First, to discuss what we call that uncomfortable conversation that you really ought to be having with clients and alerting them, and maybe some of the conversations you need to have inside your own firms and inside your corporate law firm offices. And then we're going to talk about some tools that can help you streamline your patent writing and prosecution process, because unfortunately, no matter what we talk about here, probably isn't going to change things overnight. So we're not going to be Pollyannish about that. So as I like to do to start us off, let's bring in Carrie and Megan. Ladies, what I want to try and get you to do is set the table for us as we dive in. And Carrie, I'll start with you, and Megan, I'll ask you the same question. Sort of in, maybe 1 to 2 minutes, sort of lightning round fashion. What do you want people to know about this topic as we dive into the substance? Carrie.
I think I want people to know that although things, are tough, exactly as you described, you can achieve higher quality patents at a lower price if you use data as well as smart prosecution tactics in order to obtain your patent arsenal.
Yeah, I mean, big data has really made a lot of things very possible and a lot more strategic than it once was. Right, Megan?
I agreed. And if I had to, so returning to your original question, if I had to say what I want people to come away with this, I agree with Carrie that the good news is that there are tools that aggregate USPTO data into useful statistics that can help you. But the other important takeaway is the scary news, which is another hurdle that all prosecutors face, which is significant variability in the USPTO, like in terms of allowance rates, time to allowance, application of the law, you name it. And to some extent, this isn't a surprise, right? You all know it's harder to get a patent in some technology areas than others. But to me, having worked in this field for about 4 years now, what is a surprise is variability within technology areas, so even within examiners in the same art unit. So the good news is that there are tools and tips that can help you, maybe even to leverage this variability. But the scary news is that, when we're in this climate that Jean talked about, where clients are constantly expecting more for less, and you're dealing with a patent office that has a lot of innate variability.
Yeah, there's a lot for us to unpack here, and Carrie, I want to start with you to kind of set the table for the business reality, the conversation for lawyers. As a partner, I mean, there's two things that we need to talk about. There's the one that's the conversation that you need to have with the clients, because the clients, a lot of them say, well, this is the way we've always done it. We've always paid you X to do Y. Why do we have to pay you more to do the same thing? And so we need to talk about that kind of conversation in education. But I think we probably also need to talk a little bit about the internal conversation. So which one do you want to start with? I mean, it's a multi-pronged problem, I suppose.
It really is, and I think you can look at it from two perspectives, one of which is what's happening in-house at these companies and the clients, which we continue to hear is just a steaming pot, for lack of a better word, of stress in terms of pressures to do more with less. Oftentimes, patents are viewed in those companies as cost centers, not necessarily asset centers, and therefore those budgets are heavily scrutinized, and the in-house folks that we deal with are finding themselves, continually pressured to do more with less, but still try to justify the expense and have something to show for it in their patents. On the other side, they tend to push those pressures to us as outside counsel, and what we have seen in the last few years has been an increasing use of flat fees. We have seen decreasing flat fees to where they are very, very low, and also taking the other trend that we have seen is that administrative tasks that were oftentimes traditionally within the law firm, for example, foreign filing, management and coordination, those tasks have been taken from the law firms and put to a vendor by the client. And what that does practically on the law firm side is a couple of things. It takes out a part of the process that could have been a piece of the profitable puzzle of the portfolio. It also changes your staffing needs in terms of, what support you need in order to handle the foreign dockets. So you can see how those two pressures have resulted in what we're seeing. And I think one of the outputs is this increase in vendors that are supplying services that were traditionally done by law firms. The conversations that you have to have, I think, around that internally are how to maintain, for a law firm, how do you maintain your profitability when you're losing tasks like this? Is the standard model of staffing in terms of paralegals and secretaries, et cetera, still the way to do it? Or should you think about maybe partnering with one of these vendors or some other kind of back end that will enable you to keep your profit on the work at an acceptable level so that you can keep your quality high? So there's questions like that you have to think about that result from these fees. You also have to think about whether or not you are staffing the substantive people, so from the patent agents to the patent lawyers to the partners, et cetera, appropriately. Is the work being done at a high quality level, but still within cost constraints given the necessary profit on that certain staffing? So those are, I think, the internal conversations. But the conversations with the client to help manage these pressures are, very much a traditional, I think, client conversation, which are, how can we serve you better? How can we help you do your job better? And let me tell you, we understand what's going on. So let's see if we can do this better. And part of that, I think, is coming up with actionable things to help them. So one of which that we often do with clients is have them examine how they are filing, if they're the ones directing the route in which we use to file. For example, if they're always saying go PCT all the time, every time, or if they're saying go provisional, go US, and then PCT, or however that works out, we are encouraging them to look at it more granular, so to look at it more from a technology basis to see really if your goal is lowest total cost, maybe PCT is not the way to go, and oftentimes your decisions don't really change. All this is institutional risk aversion and delay. So how can we improve that? Because if we can save, 5 to 10% per case, that can add up in your portfolio. Another thing we talk to them about is making sure that their patenting decisions are aligned with their business objectives, and we've developed some strategic algorithms with respect to that to help them make educated and objective decisions so that they can prioritize their dollar spent. And so I think that's how the conversation has changed, is let us help you. And then using other data like PTO data that Megan mentioned in terms of helping manage the U.S. side is also helpful. So that all becomes part of that conversation.
Yeah, there's so much there, and my mind is running in so many different directions. I mean, I guess the very basic first question that I have, and this is probably dependent upon size of the client, though, is do you suppose that clients have even thought about whether what they're doing in terms of wanting the same or more for less is going to have any impact on the quality? Because it seems to me that it's just, and maybe it's just because, I am a patent attorney, I know that if they tell me, look, I can only pay you less per application this year than I did last year, well, that means that somewhere along the way there's going to be less time spent. I can't spend the same amount of time on every application as I did last year, because as it turns out, we only have a certain number of hours in the day. And, I wonder sometimes whether clients or I've got to go out and I've got to hire younger associates or patent agents in order to work on a bigger chunk of that work. And that does, in a lot of ways, impact quality to some extent. And there's ways you can manage it, of course. But I wonder whether they even stop and think about what they're asking.
Yeah, I think they do, but the overall pressures and political pressures within the organizations in which they work are so geared to cost reduction and cost containment that those concerns override quality. And then when you add the concern that, or add the fact that maybe one of 100 patents will actually go to trial, and unless it's a pharma company, it may not be a bet the company patent case, you can see how the cost concerns will override those quality concerns just politically.
Yeah.
So what we try to do is say, okay, well, we're going to keep quality really high, but we're going to help you spend your dollars in a smarter way. And there are
that was what I was just going to ask you is how receptive are clients to that? Because I wonder whether when you go to, in your experience, when you go to clients like that, because I would think some would say, oh, that's great because, we have X is our budget. So if you can shave off 10% of that, with some cost-saving measures that make sense for us, then that gives us an extra 10% that we can invest in the stuff that really matters to us. But I could also see some saying, well, thank you, you saved 10% for us. That's going to make us look like heroes internally, and then they're not going to do anything else with that.
Right. My experience has been that, clients are overwhelmed by pressures that we've been talking about, and so when we come to it with a solution that says, okay, let's look at, all you're looking at in your budget really is prep and cross costs. Let's look at your official fees. What are you spending in filing costs around the world? What are you spending in maintenance fees and annuities around the world? What are you spending in foreign counsel fees? That is oftentimes more than 50, 60, sometimes 70% of their yearly budget. And if we can look at solutions that help manage that, that's where they're going to start to see the savings. And solutions can include filing the strategic way to file, finding that and using it in the appropriate circumstances, only filing in jurisdictions that align with the business, only maintain assets in jurisdictions that align with the business, and review that annually. Also, using a hub and spoke prosecution management process wherein in certain countries that the claim scope is important for your business, maybe local counsel has a little bit more leeway in terms of getting the claims. as opposed to a jurisdiction where it just matters that you're there and it really doesn't matter your claim scope, then there's no reason to let the application spin in prosecution there, and you can save costs. Every office action that you can save is $3,000 to $5,000. So if you can decide and prioritize which jurisdictions where you're going to spend those dollars in terms of official fees as well as foreign filing fees and foreign counsel fees, it can make a huge difference on your budget. And when we present this solution, I have seen, honestly, I have seen general counsel of companies fall out of their chair.
Yeah, no, I mean, I imagine that you would, because there doesn't seem to me to be an awful lot of attorneys that do that sort of thing, and that's really shocking to me. And that was, so I guess, just to put a bow on it, what I'm hearing you say is that if you engage in trying to work with your client on, good business strategy from a financial standpoint where you can help them save money, that in your experience, the clients have liked that, and found that very useful.
We call it the CFO-approved IP strategy. And
and
objective data, objective evidence, and cost savings, and then the CFO is like, aha, this isn't going to improve my business. I get it.
Yeah, and that makes a lot of sense to me. Now, one of the things that you said, which is sort of a bugaboo of mine, is $3,000 to $5,000 for an office action, and if you could save there, you can save an awful lot of money. And sometimes I wonder whether I just see a lot of the, as I always say, am I just seeing the underbelly of the industry? Because sometimes when people ask me to take a look at what's going on,
too, Gene. I see the underbelly a lot.
Because when somebody asks you to take a look at what's going on, I think I've already determined that there's something going on there that is not quite right. They may not know why it's not right, but they've already determined something's not right. Otherwise, they wouldn't ask you for a second opinion. And sometimes I look at these prosecutions and I'm wondering, how in God's name did you get onto the 8th or 9th RCE? In an application, and I believe Megan is going to talk about this in a little bit when we turn it over to her to talk about some of the tools that can help you with streamlining stuff. But, when you're looking at an examiner, for example, that might have the sweet spot is going to be they have never allowed a case after the 3rd RCE or 4th RCE. So if that case is important to you, you've got to go on appeal, or you got to abandon it, or you got to come up with a different strategy or something. It just seems like you're banging your head on the wall, and it seems to me a lot of times, and I've heard some attorneys say it, is I don't want to be the guy or gal who goes to the client and says, we got to abandon, because they know a lot of these tend to be a lot of times bigger clients. They know that they're not going to appeal, or they don't like to appeal, and they just don't want to be the bearer of bad news, so they just wind up filing an RCE. And I wonder, is that one of the reasons why clients are now all of a sudden starting to really grab hold of the reins very tightly?
I think it definitely contributes, and the strategy that we use with our clients is kind of looking at it and planning from the front end as opposed to being reactive and having to file those RCEs. And so what we look for is a filing route that will get you what we call an early indicator of your claim viability within 6 to 9 months, if you can, at least through the first year, so that before you have to make the next decision in that family, you have some educated ability to make a better decision. And you make a better decision on the front end so that you're not being reactive in a prosecution, because what that does is burn dollars, right? So if I can prevent filings in a family in 15 jurisdictions because I got an early viability report that tells me that my claims aren't going to maybe be as valuable as I think they are, or not going to be as broad, or maybe just my picture claim is allowed, I can maybe avoid those jurisdiction filing fees and office actions, et cetera. So just looking at it much more proactively as opposed to reactively is, I think, the way to fix that. But because that's not been the way that traditionally patents and patent attorneys have worked, I think we are seeing that pushback from clients.
Yeah. Now, we have a sort of a question or more of a comment here. Someone who has sort of done a little bit of the strategy that we're talking about here said that he's done that in the past, at least with one client or maybe a couple clients, and was able to shave off some percentage year over year. And then the client then expected them to be able to do the same exact thing the next year. And sometimes after you've done it one year, doing it again the next year becomes a little bit more difficult, if not, extremely difficult. I guess you do have to, when you're doing that, sort of educate the client that this may not be a situation where you're going to be able to save them 10% year after year.
Right. It's probably going to be, if you approach it like I've been discussing, starting to change your filing routes and pruning your portfolio along your business alignment, the first year you're seeing that, in the first few years as annuities are due, you're going to see huge savings, much bigger than even 10%. After that, you're going to see more incremental changes, but what you're going to be able to show, hopefully, is because there's more alignment with the patents and the business goals, that you're able to attract business opportunities because of those patents. So, for example, you're getting licensing opportunities or collaboration opportunities to acquire time, talent, or tools that you don't have already because you're building a portfolio that is really a corporate asset, and then you'll be able to show the positives of the assets working for you more easily than and less focus on cost, because if the CFO says, okay, everything I file is strategic and it falls in this index of green, we've developed this strategic index, and it'll tell you exactly, with a single number how aligned the decision is. And if you're doing that all along the way and then creating these opportunities, I think the cost conversation flips eventually.
Yeah, and so I guess if I'm hearing you, just to kind of summarize, and if I'm not hearing you correctly, feel free to tell me that and let's have that conversation. But you want to have this conversation in a way that's CEO friendly.
Yes.
Or CFO friendly is what I meant to say. So you need to learn how to talk CFO.
You have to learn to talk CFO, and you have to learn to tell them everything that all of us patent attorneys love, being in the weeds with respect to your filing decisions. Because when you're thinking about, where you're taking a family, you're looking at what are the jurisdictional realities in each of those jurisdictions. Can you enforce? Can you actually get a patent? Doesn't mean anything. How long will it take?
Mm-hmm.
All of those different considerations we're thinking about. As well as, what claims are going to be allowable. Oh, I have a software case. Then EP is probably not a great place to go. We have 50 different or more considerations we're taking into account just necessarily in our brains that overwhelm a CFO, right? That kind of personality doesn't want to hear all of this. They want to hear a single, like our index. They want to hear the index number. Okay, that's a green. I'm going to go. That's where I go. And I think you have to develop a way to speak IP in a CFO way that then justifies the expenses to change the conversation.
Now, do you have an accountant or somebody on your team that can speak that language or help you translate that language, or do you have like your business manager, your office business manager work on this with you, or do you like mood it before somehow so that you know when you're going in there that you're going to actually be able to get through the filters, or how does it work?
We have a financial analyst that helps us, exactly.
Yeah, I would think that's great. Okay, well, Megan, we've kept you out of this for a little bit here. Before we turn the presentation over to you to tell us how to actually streamline it using some of these tools, I want to open it up for you to comment on any of the stuff that we've talked about here so far. I know you're sitting in the wings, and I know you're a patent attorney as well. Do you have any thoughts on this? I know you're become the big data analytics person and have been looking at it from that standpoint, but what thoughts do you have?
So it's interesting because from what you guys are saying, it's clear to me that the job of being a patent prosecutor has completely changed since I was in the business 4 years ago.
That is so true, Megan. Yes, so true.
My job was to draft an application based on what the inventor gave me, and then to prosecute it. That was it. What do you think is novel, and push that argument. That was the end of the story. It was just as I was leaving practice that we were just beginning to ask questions like, well, is that really the best thing to do? And I think the data here, it's causing the problem, but it's also the solution to the problem. And correct me if I'm wrong, because it seems like we wouldn't even have known about how inefficient the process was if it weren't for data in the first place. Like you guys said, it seems like you're constantly seeing the seedy underbelly of the industry. But as somebody who looks at this data on a large scale, I can tell you that's because these awful cases that get lost in prosecution are happening everywhere. It's not just in one corporation or another. It's everyone, and it's because those cases are getting stuck with tough examiners.
Right.
And
no,
so,
you know, when you guys first started coming out with the data, I forget even what year that was, and when Chris Holt came up with Patent Advisor, and I remember very vividly we were talking about this, and I don't know whether it was we had webinars or we were at conferences talking about this stuff, or it may have been in comments to articles that I had written. And it was, you know, just knowing that there was art units out there that had an extremely low allowance rate was where this whole thing, you know, started back then, and examiners that had really low allowance rates. And it opened people's eyes, and they were saying, oh, my God, it's not just us. Everybody's having these issues.
It's everybody. And, you know, and I think if it's okay, Dean, I think this is a good lead-in to some of the tips that I wanted to go through today.
Yeah, no, that's why I thought this was the pivot moment. So I'd like to give you the control of the slides, and then we can add color commentary as you go through these. But go ahead, please. Right.
So prosecution tip number one is just setting client expectations based on what you think is going to happen in prosecution. So Carrie said, you know, one of the main things that's become so important in advising clients nowadays is being proactive. You know, don't wait until your 10 office actions and 4 RCEs in. You know, try to spend money wisely in the first place and set client expectations to begin with. So as I mentioned at the very beginning, you know, everybody knows that there's variability at the patent office. Everybody knows that some art units are harder than others. And so this first slide may not be a huge surprise, you know, but this is a real-life example of 2 art units within the same group. So they're actually pretty similar technology, actually pretty similar average time to allowance, but completely different allowance rates. You could end up in 1711 and have a 70% chance of getting a patent versus 1718, where you only have a 23.9% chance of getting a patent. Now, perhaps even more disturbing is that there's significant variability within an art unit. So you know, with this example, and this is an extreme example, you know, obviously that I've chosen for purposes of illustration, but nonetheless, it's not that rare. So these are 2 examiners who started around the same start date. So, you know, maybe they even went through the same training processes. They're in the exact same area of technology. But if you end up with an examiner Thatcher, you have almost no chance of getting a patent application. And so you can see a ton of people have just figured they're not getting anywhere with this guy. And 40% of cases that ended up getting patented had to go through an appeal. Whereas if you ended up with examiner L, you would have a completely different path through prosecution. So, you know, looking at this data, my guess is that if you see this data and you're outside counsel, if you just told the client, hey, this is what we're up against, just that alone, so it might be something helpful for them that could help you win their loyalty.
I agree with that. I think you could easily say something like, okay, if we change our claims slightly, we can maybe get out of Thatcher, you know, and refile. Let's see what happens. And, you know, don't lose your priority date because you file on top of each other, and just see. And sometimes clients are really excited to hear something like that.
Yeah, and I think I can't remember if it was you or Gene who said it, but I'm sure most attorneys don't want to be the guy who says, you know, maybe it's time to abandon, but sometimes when you see data like, you know, end up with examiner Thatcher, maybe it is, because I can tell you, looking at the data, who you get as your examiner matters. You know, it's not like some companies will do great with Thatcher and some will do terribly. Most cases that end up with examiner Thatcher are going to be difficult. So pay attention to who you get as your examiner. So the second tip that I have is to start making your strategic decisions as early as the drafting phase. So when I started out as an attorney, we weren't, you know, the only strategic thinking we were doing at the drafting phase was, you know, how am I going to characterize this application so that it seems like the technology is novel? You know, how am I going to draft it to have the broadest claims possible that still cover the technology? But now there's a whole lot more than that. So in particular these days, anyone who works in the realm of computers and software knows that they have to be very careful when drafting to try to avoid an Alice rejection. And whether or not you can overcome such a rejection appears to come down, to how you draft your claims. So a blog posted by a friend, Mark Notarski, recently concluded that, for most examiners, the only cases that have been allowed since Alice have claims that incorporate physical devices. So this guy, he actually went through a random sample of 100 cases that have been allowed since Alice, and he lists out specific words that were used to overcome the rejection. But my
and that's interesting, really. And this may be changing a little. We got to keep our eye on this simply because of the Berkheimer memo and stuff. But the takeaway here, I think, is got to be that what you need to do is you need to draft your applications to satisfy the machine or transformation test. And that sounds almost idiotic, but that's really sort of the takeaway. Because examiners are really comfortable with things that they can touch and they know, and they're just not comfortable with these things that sound in business methods where there's nothing tangible there.
Right.
I agree with that. Another point on drafting with purpose that we have moved to and clients are demanding is that when we draft the original case, it complies with multiple jurisdictions in terms of the rules. So we have EP language that would support, for example, the best 101 case we could get, or at least you're putting that language in there to get the claims later. And so not only are you having to draft it for the U.S., you're also having to draft it for other office in the world.
Yeah. So we have a tool at LexisNexis called Pathways. And obviously, this is only going to be helpful for what you're doing in the U.S., but in that realm, it is very helpful. And so what Pathways does is it helps predict which technology-centered group your application is likely to be assigned to. And then, if you don't like it, the idea is to help you to try to draft your claim or your application in a way that you'll be assigned to a different one. So, regardless of what it takes to overcome Alice rejections today, your best chance of overcoming an Alice rejection, right, is not even to get one in the first place. So try to get out of the.
Amen.
Yeah, try to avoid those arguments in the first place. But this issue isn't just limited to Alice, and I think that's an important point. I mean, no matter what your technology area is, there are just some arguments that are easier than others. Each argument has its own fee. They have a different prosecution style, and so it's important to try to aim for one that is a little bit easier. So I'll take an example just so you can see how this tool works. So say your client comes to you with an invention on a trash bag that doesn't smell. You can put the stinkiest thing in the world in it and it won't smell. So I just characterize it offhand as a trash bag that prevents odor buildup. And I don't know if you can see in this slide, but it looks like the technology set of groups that you'll end up in likely have, middle of the road allowance rates. You've only got a 1% chance of ending up in this one that has a decent allowance rate. But what if you could draft it in a different way? Maybe think of a different way to characterize that trash bag. So, for example, maybe you call it an organic compound configured to repel odors. And then all of a sudden, you're likely to end up in a technology area where your chances of allowance are drastically improved.
And let me say something, because I know you said that this isn't all about Alice, and it's certainly not all about Alice. But being a software guy, that's probably the area I know best. And one of the things that we've looked at is that even within 3600, and that's people kind of probably know that 36, you didn't sign the 3600. Oh, that's the kiss of death. But if you actually look at the arguments in 3600, the 10 of the worst 20 art units are in 3600, but 10 of the best 20 art units are also in 3600. I mean, 3600 is a completely mixed bag. So a tool like this can really, really be very helpful. I mean, because if you get signed to the Valley of Death, good luck. Good luck. I mean, we'll see what the Berkheimer memo does to some of these valleys of death. Like 3689 that has had single-digit allowance rates for pretty much as long as I've been a patent attorney. But But, you know, I didn't mean to interrupt. I just wanted to point that out for people that this tool really is extraordinarily important, I think.
Yeah, no, I'm glad you feel that way from a practical perspective, you know, as well, because I'm just sitting here looking at the data, and I almost wish I had included it. I have a chart that shows the allowance rate for all the art units of the USPTO, and it's funny that you use the term valley because that's what this chart is. It's just peaks and valleys. Sure, the biggest valleys are in 3,600, but there's peaks and valleys everywhere. So, you know, before you even start drafting your application, it's really important to know where those valleys are and to try to avoid them. You know, you can't pick your examiner, but you do have some control over the group of examiners that your application goes to. So, yeah, use it. So my next tip, and this still applies at the drafting phase, and perhaps this one is obvious, but I just want to make sure that everybody knows that there are tools out there to help with this. Well, I think Jean, you were saying, or Carrie, you were saying, you know, each saving one office action is what, $3,000 to $4,000?
Yeah.
Do not be wasting time on 112 rejections, right? That's one thing that you definitely do not want to have on your plate. And if you an overall review of the U.S. Patent Office, anywhere from 25 to 90% of first office actions have a 112 rejection. You know, in the biotechnology space, there's obviously going to be way more 112 rejections just because of the nature of the technology. But even in more mechanical tech centers like 2800, 28% of first office actions have a 112 rejection. And there's just no need for that. There are tools that can check your claims for claim anomalies, you know, make sure that there's no lack of antecedent basis. They can even check the drawings to make sure that you're being consistent in your numbering. They can check your measurements, you know, to make sure that you're converting correctly from one system to another. So LexisNexis, our tool, Patent Optimizer, can help you with this. But there's just no reason not to use a software like this to fix those obvious errors that are so easy for a computer to find, but kind of hard for a human.
Yeah, and can I say something there too, Megan? And so if anybody thinks that's too infomercially, blame me because I'm the one that asked Megan to put those slides in there specifically, because I talk to examiners, as you probably can imagine, quite a lot. And I've actually over the years become friends with a number of examiners, and have had some people, because I live in the Northern Virginia area, who I've known since they were young kids now become examiners. The one thing I hear from every single examiner, I ask them, you know, what can I tell the attorneys that I talk to that the one piece of advice that you would like me to give them? And without fail, the first thing out of every examiner's mouth is tell them to get better at 112 rejections, because they all say it's a waste of my time. And, you know, because they have to spend so much time on a 112 rejection, and they see it as busy work, and it puts them, I think, in a bad. And this maybe I'm projecting, maybe I'm reading into it, but it puts them, I think, in a bad mindset as to, like, why are you making me go through all this busy work? Because that's how it's characterized to me, that 112 stuff they feel is busy work. And they would rather be able to spend the time that's allocated to them looking into 102, 103, and really getting to the heart of the matter, at least the examiners that want to issue or that are being reasonable. So if you can really work on getting better at 112, and there are tools that will help you do that, I think that is going to be an enormous way that you're going to be able to streamline your prosecution, get to yes much quicker, save money for clients, and show much better results quicker.
Yeah, I totally agree. And Jean, I've heard similar things from talking to examiners. So, you know, it's not something you even need to really take that much time to do. You know, have a tool that does it. But I may be slightly biased since I come from a company that does these tools. Okay, so the next two prosecution tips are actually the one after this. So sorry, I was jumping ahead here. My next prosecution tip has to do with devising your substantive arguments during prosecution. So obviously you want to keep the number of office actions down, so you want to use arguments that are actually going to be effective. And this may or may not surprise you, but I can tell you that many examiners have a tendency to use the same types of rejections. So just one example, and we see this a lot, is an examiner who loves the non-functional descriptive subject matter argument. So I see that you put these words in your claim, but I'm going to pretend that you didn't, argument, which we all love. And there are definitely examiners that favor that. I think we've all come across examiners who tend to use the same pieces of prior art over and over and over again. And then, of course, there's the ever-present omnis Alice rejection that examiners will apply over and over and over. So, you know, using case law with these examiners, helpful, sure, sometimes. But I think maybe the most persuasive thing that you could do is to say, is if you can say, hey, I know that somebody else used this exact argument with somebody else, and this is how they overcame it. So I can overcome it the same way. Why won't you allow it in my case? You know, to show them that they have actually allowed an application using a particular argument. So again, you know, it doesn't sound too much like an infomercial, but there are tools out there that will allow you to search the full text of image file wrappers at the USPTO. The LexisNexis tool within Patent Advisor is called PatDoc Search. So what this allows you to do is to search a particular examiner or art in this body of work, or even heck the whole patent office if you want to, for a particular argument or prior art reference to see how other applicants have been successful. So maybe you can try to mimic what they've done. So, you know, and it's difficult with prosecution, because I actually started off working as a litigator, and it's like, well, you know, you do your Westlaw search to see what the case law out there says, but in the prosecution world, I find that, you know, if the examiner has said something in the past, citing that against him or her is probably going to be more useful than anything. So use the right arguments that are going to hit home right away to help try to minimize your number of office actions. Okay, so these are the next two tips that I was originally thinking about. These I can already hear that there may be some negative feedback on these, because basically what I'm going to tell you is that you need to be considering the appeal process maybe more than you are already. And I can already hear you saying, like, well, wait a second, this is all about, like, saving money and being more efficient. Why would I want to ever appeal more? And I hear that, but if a case really matters, sometimes taking a case to appeal actually is what makes the most sense. So the situation I want to talk about first is where you have an application on appeal, but the examiner throws it out by issuing a non-final rejection with new art. This is a really common pattern that we see at the USPTO. And of course, how common it is depends on where you are. So for example, in Tech Center Group 3690, we see that applications are pushed back into prosecution 23% of the time. In Tech Center Group 2690, they're pushed back into prosecution 19% of the time. Overall, it's about 20% of the time that applications are pushed out of the appeal process. When this happens, I don't think a lot of people think about immediately pushing their case back into appeal. They probably think, all right, you know, this is a win. Like, I won on this issue. The examiner conceded I'm right. So maybe I'll just keep working with the examiner. And I'm not even sure some people know that you actually can just reinstate appeal without paying any additional fees. The CFR and the NTEP provide the option to reinstate the appeal without any additional fees, you know, unless, of course, the fees went up in the meantime. So this is, you know, an option. And there's not a time limit on it either. So you can do it at any time. But like I said, I don't think that many people actually do it, and I certainly don't think that many people are considering the statistics on whether or not they should push their case back into appeal. But I can tell you that there are situations where the numbers make sense for pushing it back into appeal. So actually, rather than going through the factors, I'll give you a specific example. So say you have a case with this particular examiner, Golden. Right, not surprisingly, with her 19% allowance rate, you're thinking, I'm going to appeal this case. And then after you file the brief or something, she issues an office action. Well, that means you're stuck back with negotiating with her 19% allowance rate. Maybe it would be better to push the case back into appeal so it gets all the way to the board, where you'll see that, you know, the majority of cases are actually allowed when they make it to the board. 16 applicants had their cases actually allowed, whereas only 13 abandoned, and there was 1 RCE. You know, there are fantastic statistics, but the statistics in front of the board are certainly better than the statistics for working with her. So, you know, what I don't know is I'm not sure how receptive clients are to this strategy. You know, Carrie, maybe you could give us a better idea of, you know, how a company might react if their counsel came to them and said, hey, you know, no, I don't want to keep working with this examiner. I want to continue in the appeal process.
I think a lot of the clients that are patent savvy appreciate that. The clients that are less savvy, trying to explain to them, you know, why we want to go to appeal and the fees that would involve sometimes is a little more difficult. I think it oftentimes just depends on how much savviness they have in terms of their reaction. But overall, I think clients have a favorable response if you're saying, look, you're in a difficult position. We're trying to save money in the long run. We're going to do this. What do you think? They appreciate the creative thinking.
Well, that's good to hear, you know, because my next tip is probably even more controversial and maybe even more something that the client doesn't want to hear. And that is to consider appeal after the first final in some situations. You know, if you've got a really high business value patent and you end up with a really difficult examiner, because for some examiners, it's just the fact that appeal outcomes are statistically more favorable than RCE. And this will surprise you not at all, but that is the case, for example, in 3690, which is the business methods group. But also, I found that it's the case in Texana Group 2690 for selective visual display systems. So your chances of getting a notice of allowance after the first RCE are pretty pathetic, but your chances of getting your application allowed if you push it all the way to the board are, frankly, better. And so if you have a high business value case, you really care about your claims, you don't want them contaminated by a long prosecution, a long file history, and repeated amendments, maybe it makes sense to actually appeal at the very beginning. So, you know, just another example of an examiner where that might make sense. Here's this guy, examiner, I'm not even going to attempt to say that, I'll say examiner Musk. And you can see, so he's got an allowance rate of 45%, you know, which is decent. But the chances of getting an allowance after the first RCE are only 9.8%. And 40% of applications already have one RCE. However, the chances of winning an appeal are over 80%. So, you know, assuming you've got good claims, assuming your claims are in condition for appeal, you know, I would get them in condition for appeal early and seriously consider appealing early, maybe even after the first final. So, again, Carrie, I don't know how a client would actually respond to this because I personally have never done it, but I can tell you that statistically sometimes it makes sense. So my final tip.
Well, one of the things, I mean, one of the other things to think about here too is you know, and there's been a number of people I think who have done this, and this strategy may not be the greatest strategy anymore. You got to look into the appeals backlog and so forth. But when appeals were really had a high backlog and software was really at its worst location in the world, there were a number of clients that would appeal simply to park the application on appeal. Because the reality is if you've been doing software for long enough, you know that the law over the last 30 years, maybe even longer, has never been the same for longer than 2.5 years. And that's really been true. You know, we saw even with Alice, it was about 2.5 years after Alice that we got EnFish, and that sort of broke through a bit. And then now we got Berkheimer, and that's breaking through even more and changing things. So the law of software has always been moving. So people sometimes will just park things on appeal. So that's not always the worst strategy. But it requires a client that really kind of understands. And again, I think it's important that you're pointing out there's got to be a high business value asset as well.
Sure.
And a lot of these strategies we're talking about is not one size fits all, you know, and it's not depending on the size of the company necessarily either, because some of these companies could be startups. It could be a foundational patent with some funding from VC or something with maybe some ideas that this company is going to grow and maybe go public or what have you, and that patent may be, in their eyes, just as important to them for very different reasons as a blockbuster pharmaceutical, even though the value is, going to be very different. But it is maybe no less important to the company,
Right, and I'm glad you mentioned that because somebody just asked a really good question, which is, well, aren't these appeal statistics skewed because only people who really believe in or care about their case are going to go to appeal in the first place? But one, there's a lot of reasons that people go to appeal. Like you said, sometimes they go to appeal just to park the case. And two, just because the patent is a really high value to the applicant, I don't know if that necessarily makes it any more patentable and therefore likely to be successful on appeal, because there's a lot of reasons that a patent could be valuable that aren't necessarily tied to its patentability. And finally, in response to that question, I would say, even if that is true, I can still tell you that there are some examiners in some technology areas where the percentage of appeals is just so much higher than in other areas. And I can also tell you that the outcome statistics do look very different depending on where you are. So just looking at the statistics alone, I'm not seeing any type of huge systematic bias at that level.
Yeah.
But it's a good question.
Right.
So
yeah, I mean, sometimes examiners don't really, unfortunately, take it as seriously as you might want them to take it until you are willing to go on appeal. I mean, so the statistics really are, in some ways, the first window that gets opened. And they sometimes will raise more questions than they answer. But when that happens, you have to look. And the fact that the statistic maybe doesn't answer the entire question, I think only makes it all the more important that you know that statistic.
Agreed.
Mm-hmm.
Yeah. So, and whoever asked that question, I hope you maybe look into it a little bit more and come back to us with anything that you learn. And so my final tip is to do your homework on pilot programs. This is funny because this is one area where I think people actually do look at the statistics just because they're always new, and so people are always asking, oh, how is this working for other people? But I think it's worth mentioning anyway, because in my experience, the statistics on these things can actually be really surprising. So for example, my friend Kate Audrey did a paper on track 1 a few years ago, where she discovered that not only does track 1 get you a patent faster, but it's also just way more likely to get a patent if you file with track 1. So again, maybe this could be explained away by some reason, like maybe, people only file track 1 on important cases, but maybe it's more. Maybe examiners know they have to get to these cases quickly, they know they're more important, and so they place more value on getting them through the process quickly. And also I can tell you, the allowance rate jump is pretty significant for some tech areas.
Well, and building on that point, Megan, we have done the financial analysis to show that even though the track 1 has a fee, it's $4,000 for large entities, so it's fairly expensive, even paying that fee over a family, because theoretically in about 12 months, you know exactly what your claims are going to look like, and therefore you can take them into the foreign jurisdictions without having them spin in all of your different jurisdictions. And you can save a tremendous amount of money approaching prosecution like that, even though the outlay for the fee was higher, because you have gotten a very reliable early indicator in this track 1 process of what your claims are, and the other offices will take it. So we have found this financially to be very sound, which is somewhat counterintuitive.
Yeah, again, it's kind of the same thing with the appeal. Sometimes you have to shell out a little bit more money initially to save money in the end. But I guess that's like anything in life.
And it bears out. It definitely bears out. We've done many different scenario runs.
Yeah, so that's good to know that in the real world that this actually does bear out. So do your homework on these things. Track 1, pilot program. As with everything, I'm going to tell you that the success of these programs will vary based on where you are at the USPTO. But check it out, because for any given application, you want to see what your chances are for using these programs.
Very good, very good. So we have a few minutes remaining here. to get to a few questions. One quick one, Megan, is what was the name of the claim check software on page 10? That was when we were talking about the 112. That's Patent Optimizer, correct?
Patent Optimizer. Yeah, sorry I didn't put that on the slide. And it does way more than just check your claims. But yeah, that's
right.
Patent Optimizer.
Yeah, it checks the claims, it checks the spec. It does a lot. I mean, it does actually. When I've had a demo of that, my head has spun at just how much it actually does. So if you're interested in that, I would suggest a test drive and be ready to geek out a bit on that. That's really powerful stuff there. The other question, Carrie, this is for you. What advice do you have for bringing together a cross-disciplinary team in order to look at these in a different way, a way that may be different than what a patent attorney might look at it, in order to really put together, whether it be a pitch or an explanation that clients can digest in a way that allows them to make a decision?
I think the key is finding a common vocabulary that everyone understands, and you don't approach it from a I'm a patent geek. You don't approach it from a patent geek perspective that is explaining all of the nuances of the weeds. You come up with a vocabulary that everyone can understand, everyone can get into. So, for example, this strategic index and ranking and triage that we use, it enables everybody to understand that and then understand the purpose of what you're doing. And so the decisions are easier to make as a group. And part of that strategic analysis includes the business actuality. So what is happening in the business? Why is this important? What's going to be happening now? What's happening in 3 years? What's happening in 5 years, et cetera? And so that conversation can really facilitate getting to this common language, and I think that's the key.
Yeah. Now, we've had a number of people ask about the slides, so obviously they thought you did a good job on the slides, Megan. You'll all get the slides sent to you via email, and everybody registered, along with a recording of the webinar. So you'll all get access to the slides. And we have another question here, or actually more of a comment, is one way I integrate patent value discussions into my everyday practice is by asking the client to articulate the relationship of a patent application I'm working on to the actual business of the client throughout prosecution. And I think that's a good strategy, and I personally don't think enough patent attorneys really do that. But, Carrie, I think that is one way to make sure that the client is continuing to think about whether what they're doing really fits that business strategy.
Absolutely. I think that's why part of our strategic process looks at the business actualities, what's going on, and includes them, and actually tries to turn the IP counsel into a strategic advisor and counselor as opposed to just a patent prosecutor.
Yeah, and that's a lot of patent attorneys aren't all that great at that, and it's not a dig. It's just I always tell people patent attorneys are really good at getting patents, really good at telling you whether you're going to get a patent. And I think the business has changed, and I think patent attorneys need to evolve a little, and work. And if you're not good at that, I do think pulling together people from a multidisciplinary team in order to have that is going to become increasingly important for the practice. So I'm looking at the clock, and we have a couple minutes left. And ladies, I would like to give each of you a chance to, wrap up parting thoughts and takeaway messages. So, Carrie, since I started with you, we'll let you have the last word. And Megan, I'll let you go first. And I'll ask both of you the same question. What is the one thing that you hope people on this webinar will leave remembering today? So, Megan, you first.
So at the risk of sounding a little bit like a broken record, I would say that in a lot of ways there is an examiner lottery at the U.S. Patent Office, and so it's really important to know who your examiner is and what they've done in the past, because I think that can guide your entire prosecution strategy from day one. And from what I've been hearing about the way the practice is, absolutely should guide your prosecution strategy.
Great. Thank you, Megan. And Carrie, final words.
Bringing it all home, yes. I think the message is there is hope to surviving both outside counsel and inside counsel these pressures that we're under, and part of it is changing the way you think about prosecution and thinking about it much more proactively, using data, using ways to involve the business and get those business actualities and realities in there into those decisions making. Because if you can do that, you can get higher quality assets while reducing costs that you're being forced to. So I think there's hope is the message.
That's great, and that's a great message to end on. Thank you, Carrie. Thank you, Megan. Thank you, LexisNexis. And thank you, Gail, for kicking us off and being our producer today. And thank you all for spending a part of your Thursday afternoon or morning with us, depending upon where you are. And we look forward to hopefully having you join us for another webinar in the future. So have a good day, and we will see you again soon.
Thanks, guys.
Thank you. And if anybody has any questions, reach out to any one of us.
Absolutely. Thanks, guys.